On a very sad, very serious note, when I was a state's attorney, and that was more than 31 years ago, I had a case where a little boy was burned severely by his mother by being plunged into a tub of what was in effect boiling water. And it was a very difficult case to prove because she was a very sympathetic, very young woman. And she kept claiming that the child had done it to himself because she had left the child in a bathtub of water running, and he had somehow clogged the drain with a washcloth, which is what accounted for the water not draining, and had accidentally turned the water from cold to hot, and he had done it himself. And it was a case that I've always remembered, in part because the child nearly died, but he didn't. And partly because it was probably the best tried case I personally have ever done.
What's up, All-Stars? Welcome to the School of Ireland. You are about to watch an epic conversation that I had with retired U.S. Attorney Jane Nathan. And let me tell you, she has some incredible stories to share from her time as a state and federal prosecutor. You'll also get to hear us talk about some tough questions like, should eyewitness testimony be used in court? Because as psychology students would know, human memory isn't that reliable. I also asked her, are there any problems with the legal system? I promise you, you will not be disappointed and that you will take away a lot from this conversation. But before we begin, however, I wanted to give you a heads up that we do talk about some very sensitive topics that may not be for all audiences. Otherwise, I hope you enjoy. So, first question, you're now a retired U.S. attorney. Do you miss it?
Correct. Very much so. In fact, I'm actually making some movement toward maybe becoming reemployed, probably not by the U.S. Attorney's Office, because I don't live close enough to the one that is in the state in which I now reside. But I have looked a little bit into getting back into state level prosecution because I do miss it very much. It's the best job anyone could ever have. And state, federal, doesn't matter. It's just for me, it was the best job I could have ever had. And I'm one of the very lucky people who managed to find their niche in life early. And it was a perfect fit. And I loved every day that I worked.
What made you want to get into law in the first place?
Well, that's a good question. I had not really thought much about going into law, but I come from a family of police officers. And when my first dream for a job petered out because I realized I didn't really want to be a doctor, it was just one of those things that I said as a child and people went, ooh, that's pretty cool. And so I think I really wanted the reaction to my goal rather than the goal itself. I realized after college that I was in a position where the field was wide open. Any job that I could have imagined, I could now go for because I wasn't stymied by this commitment to going to medical school that, frankly, I never really wanted. So I originally became a police officer right out of college. My father, my grandfather, my uncle, my cousin, they were all police officers, and it sounded like a fascinating job. It sounded like a job that there was something different every day. It's not a job where you sit at a desk. Back then, we didn't have computers, and did paperwork. And I couldn't, to this day, I can't sit for very long. So I'm not really cut out for that type of job. So I went ahead and I applied to the Prince George's County, Maryland Police Department. I was accepted. I became one out of 4 women in a class of 26 men. It wasn't always easy. There was still a whole lot of prejudice against women in the legal field, in the policing field, even from other police officers. I mean, I can't count the number of times I was told that I had taken the job away from a man who needed it to support his family, and therefore I should just give it up. But I graduated first in my class and went on to the Prince George's County Patrol Division. I worked in the Hyattsville substation. And I did that for about 3.5 years when I decided that it wasn't quite, I needed to tweak it. It wasn't quite what I wanted to do. I went to law school, graduated from the University of Maryland in Baltimore Law School in 1983. I did a very, very short stint in private practice with another practitioner. I was an associate in his firm. I hated every moment of it. And I kept applying to the state's attorney's office in Prince George's County, mainly because I knew most of the people, having been a police officer in that county. And I think they finally just gave me a job to get rid of me. Every time I was in the courthouse, I would knock on the door and say, I'm still interested. I still want this job. And one day they said to me, I'm sorry, but we just filled 3 positions and all 3 have accepted. And I thanked them and I left and went about my business. And I opened not the courthouse, the elevator doors opened as I was leaving, and I came face to face with the woman who had just told me that there were no positions. And she said, you're not going to believe this. Someone who had accepted one of the 3 positions just canceled. Do you want this job?
Wow.
And it was not just serendipitous, but I think it's a testament to how much just perseverance can make the difference between getting the job of your dreams or not. I mean, if I had just been too embarrassed to go back for the 3rd or 4th time and knock on a door and say, I want to work here, they wouldn't even have known I was in the courthouse. But I was there, and some of it was just dumb luck. You're in the right place at the right time. If I hadn't been there, if someone else had been, they would have gotten the job. But I did that for about 5 years. I went through all the divisions, including district court, which is misdemeanor, circuit court, which is felony, screening, which is deciding what charges are to be placed, and juvenile. In the felony division, we were told to pick areas of concentration. They couldn't guarantee that every case would be in that area, but by far the bulk of your cases were. And I picked the sex and child abuse unit, which is a very difficult, very time-consuming, and very gut-wrenching area to practice in. But I felt very committed to my victims. And if I was going to be working on a Saturday, a Sunday, or a weeknight late, I wanted to have that little face of the victim or the woman in my mind to tell me why I was being separated from my family. After about 5 years, I had gotten a call from a friend who I'd worked with as a state's attorney, and she had moved on to the U.S. Attorney's Office in Maryland. She had a son who she wanted to stay home with part-time, but the job had grown over the 3 to 4 years she had been there. It was now basically a full-time job, and she was given permission to find another attorney who she could job share with. And she called me and said, I understand you're interested in part-time. Would you like to come split a job with me here at the U.S. Attorney's Office? And the only downside is that it would only be misdemeanors. I would never do felonies. But I thought about it and I said, yeah, I can do that for my family. So I accepted and I started the job in October of 1989. And I stayed there for 30.5 years until April 30th of 2020 when I retired.
That's awesome.
Thank you.
Now, so did you ever consider doing defense?
No.
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 It was always get the bad guy kind of thing, or the
No,
lawbreaker.
it's not just that. People tend to think of the defense and the prosecution as being mirror images, like my hands are, but we're not. As a prosecutor, I have so much power, and everybody who's a trial attorney has an ego, and I'm no exception. I loved the power. I loved knowing when I walked in that courthouse, that was my courtroom. Yeah, the judge thought it was his, but I'm the one who decides what cases get tried. I'm the one who decides what cases don't go forward. I'm the one who decides how to present my own case. I don't have to answer to not to a victim, of course I do, but I don't have to answer to a defendant. But it's not just the ego. What I really like about prosecution is, number one, you do feel like you're on the side of the angels. You know, you are trying to get the bad guys. But my favorite part about prosecution is I had a conversation once with a dear, dear friend who I love and respect enormously, and she is a public defender. So, you know, she gets some people that are not very admirable. And I was saying something once about justice, and she said, justice has nothing to do with what I do. I never have to consider that. And she's right, she doesn't. She has to defend her client to the best of her ability, regardless of her belief in the goodness of his position, in the rightness of his position. And if she gets him off when she knows in her heart that he is, in fact, guilty of the crime, if not legally guilty, it doesn't bother her. because justice isn't something she has to think of. And I said, but justice is something that's always on the forefront of my mind. And that's what I like. She has often, daily, defended people who she, in her heart, knows is guilty. I have never once in 35 years of prosecution prosecuted anybody that I didn't believe was guilty. Now, I may have been wrong once or twice. I'm not saying I've never convicted an innocent person, but I've never done it knowingly. And if I grow to believe that the case that I have against the defendant is marred in some way, or he is in fact, or she is in fact not guilty of the crime, not only may I, but I must dismiss those charges. And so we're not mirror images. I don't prosecute regardless, although a defense attorney defends regardless. Mm-hmm. And I like knowing that I have that freedom. I have never had to prosecute somebody who I didn't feel was guilty or I felt did not deserve prosecution.
So when those cases get dismissed on, I guess, your decision, is that when new evidence comes to light, or?
Sometimes it's new evidence. Generally it would be. I have actually, although I can only think of it one time, I have actually stopped a trial in the middle of a trial and said, Your Honor, I make a motion to dismiss these charges.
Wow.
Because I cannot remember, you'd think I would, that I cannot remember exactly what my witness said, but whatever it was, it just made it so clear that the defendant had not done what he or she was accused of. And I just couldn't in good conscience go further. And the judge, he had, bright man, he immediately had seen the issue as well. If it's a technical difficulty, I might proceed. If it's something where I believe the defendant has done what he is accused of doing, but my witness dies, as did happen to me once. I had a young man who was my witness, and he was killed in a motorcycle accident 2 days before the trial, and I went forward. I ended up taking a plea to a lesser charge, but I did go forward. That would not make me dismiss a case. I'd rather go down fighting. But if something happens that made me feel that the defendant did not, in fact, commit the actions that constituted the crime, I just dismissed the case. And generally, yes, that would be new evidence.
Now, are you the one who gets to decide what charges are brought against the defendant?
Eventually. A defendant is brought into my courtroom already charged by the police officer in a misdemeanor case.
Sure.
He's already, it's done, it's much more reactive. In felony world, it is much more proactive. You get a case, you talk to the witnesses, you talk to your victim, you study the forensics if there is any, and then you decide what charges should be brought. In a misdemeanor case, which is the bulk of my practice, the police officer made a decision on the street. And most of the time, not always, but 99% of the time. And one of my jobs would be to review those charges. And sometimes officers charge with the wrong offense. I mean, they don't quite understand the law, and they charge an offense where the factors don't justify the charge that was brought. Sometimes they forget charges that are important. So in misdemeanor practice, eventually I would review them and tweak them, but they were brought to me already charged.
Now, did you ever, and now I'm going to make an assumption here.
Mm-hmm.
Do civil lawyers make more money on average than criminal?
Everybody
lawyers?
makes more money on average than prosecutors
Okay.
or public defenders.
Okay.
Or public defenders. Private practice always makes more money. Yes.
Did you ever consider that, or?
Did it ever cross my mind?
Yeah.
Yes. But did it bother me? No. If I was in it for the money, I wouldn't have been a prosecutor. I would have done it 5 years and then jumped into private practice like many, many people do. And there's nothing wrong with that. Mm-hmm. By far, the bulk of your state prosecutors, especially, are doing it because they want to get the trial experience. And that's the best way. Nobody in this world is in court more, well, maybe a judge, more than a prosecutor, even a public defender, because they may have 10% of my cases in one day and the other 90%, or they may even have 90% of my cases and the other 10% are private practice, and a couple stray defendants are representing themselves, but I'm there for every single case. Mm. So a lot of people just do prosecution for a few years and then they go into private practice and parlay it into a good paying job. But no, I had no interest in doing that.
Is a public defender, are they a government employee?
The public defenders in the U.S. Attorney's Office are government employees. They are part of the judicial branch, as the prosecutor is part of the executive branch. So we're not in the same branch of government, although we are counterparts in court. So yes, they are paid through your tax dollars. Yes.
Then why would a lawyer do a case pro bono?
Kindness, idealism. Sometimes they want to, sometimes they know the defendant. Sometimes it's a pet peeve of theirs. Like, I knew a man who took a case against me because he believed the government was harassing this poor landowner and trying to steal his land. And I couldn't convince him. Well, actually, I think I eventually did, that the land that this man was claiming was not his. It was actually belonged to the government. It was part of one of the federal parks. And he took it on a pro bono basis because he was a new-ish attorney and he was trying to build a reputation, and because he felt strongly about it. Most big law firms will have a certain amount of a percentage of their cases will be pro bono. It won't be a lot, but it'll be some, and they will encourage their associates or even perhaps their partners to take on pro bono. It's a PR thing to some extent. There's a lot of different, it makes them look good, but also it's done out of a true sense of representing people who can't afford their own attorneys. Of course, the answer to that isn't get a public defender, because despite what sometimes people believe public defenders are, in my opinion, they're the finest. Next to the prosecutors, of course, they're among the finest attorneys I've ever come up against. And part of the reason is that they don't have to worry about money.
In the same realm as that, what is your relationship with defense attorneys? How has it been in general?
Oh, very good. I think there's an idea that prosecutors and defense attorneys don't get along, when in fact that isn't the case at all. We get along for the most part. I think most defense attorneys know their clients are guilty, and they know that they're just doing a job. And I know that they know I'm doing a job. I know that they're doing a job. I've had some that were aggressive and ugly and nasty. They seem to think they have to posture for their clients, which they don't. In fact, it gets them nothing. It only irritates the prosecutor and irritates the judge. But for the most part, I've always been good friends with the defense attorneys I came up against, especially the public defenders. There's three of them, just coincidentally, they're all three women, who two of them I consider very good friends, and one of them a friend, not quite as close as the other two.
Something I've always wondered is, do lawyers watch crime shows?
Some lawyers do.
Did you?
No. I watched a few. They're so silly. The law is so sloppy. The ridiculous things that they do. I remember Law and Order once, where the prosecutor and the defense attorney just happened upon the judge in the hallway, and they started arguing a motion to suppress as the judge walked through the hallway, and they were following him or her in the parking lot where the judge ruled. And I thought, Since when do we not do this in court with a court reporter, witnesses, somebody to take down what's being said, either record or actually a stenographer? The law is always really sloppy, and it's just frustrating when you see the stuff they do. I mean, they're so fake that I can't even enjoy them anymore. It's like my sister, who's a nurse, doesn't watch medical shows for the same reason. Yeah.
As a social studies teacher, I absolutely love hearing people's stories. And you've come in and talked to my students before. And when you do, one of the things they love the most is hearing your war stories. Do you mind sharing any?
Yeah. Do you have a topic that you would prefer that I mean, which one? I guess is what I'm asking.
True. Well, actually, before we go into that, I actually have another question. I think because of criminal TV shows, there's like a misconception that almost everything goes to trial, but that's actually very rare. So what percentage of cases actually go to trial?
I would say 5%. I mean, that's a rough guess.
Wow.
In misdemeanor practice, again, the vast majority of them plea out for various reasons. One is that by the time it gets through the investigators or the police officers, the U.S. attorney or the state's attorney, by the time the motions to suppress or for additional information, additional discovery has been gone back and forth between the defense and the prosecution, the case is tight or it wouldn't be there. If the case was that shaky, chances are it would not have gone that far. So by the time we're in a posture of facing a trial, the defense attorney knows that his client, he knows what's up against his client and will generally advise them to take the best plea they could get. But not always. You sometimes get a client that, despite the defense attorney's encouragement, says, no, I'm taking it to trial. I will not plead. You sometimes get a defense attorney who just, there were some that was just known for not wanting to plead anything. And frankly, I don't think they did their clients any favors, because they ended up getting convicted of all the charges, because I'm not dismissing any charges, if it's not a play.
Yeah.
And you end up you lose any acceptance of responsibility you get at sentencing. And I know defense attorneys are very upset about that. They say it's a going to trial penalty. And I say, no, it isn't. What it is that you're not getting a benefit that you would get if you saved me the time, money, and the court and effort of just pleading. You don't get to fight everything tooth and nail and then get a reduced sentence for acceptance of responsibility because you haven't accepted responsibility. So the vast majority of cases do end up pleading out because our evidence is generally pretty strong.
Yeah. Oh, in terms of war stories, I mean, what are cases that stick out, thinking back?
Oh boy, on a very sad, very serious note, when I was a state's attorney, and that was more than 31 years ago, I had a case where a little boy was burned severely by his mother by being plunged into a tub of what was in effect boiling water. And it was a very difficult case to prove because she was a very sympathetic, very young woman. If memory serves, and I might be getting some of these facts wrong, she was 21. She had 2 toddlers, including the one she burned, and she was pregnant with twins. She was living in an apartment with a lot of other people. I don't believe there was a husband or a father of any of the children involved. And, she was young and attractive and kind of appealingly ditzy, if you will excuse that expression. And she kept claiming that the child had done it to himself because she had left the child in a bathtub of water running, and he had somehow clogged the drain with a washcloth, which is what accounted for the water not draining, and had accidentally turned the water from cold to hot, and he had done it himself. And it was a case that I've always remembered, in part because the child nearly died, but he didn't. And partly because it was probably the best tried case I personally have ever done. I had everything from forensic evidence in the form of a doctor who testified as to splash patterns on the child's body. I had the forensic evidence in the form of the plumber and the superintendent of the apartment complex, who would testify to the temperature of the water by the time it left the hot water heater in the basement, and how many degrees, if any, that it would cool by the time it got up to her apartment. And I had spent days and weeks and months on this case, and I felt so strongly about it. And eventually we did get a conviction. She was only given probation, which is because, again, she was a young and she had no priors. She was a sympathetic woman. She had a lot of family and friends and relatives who said she was a good mother. And frankly, what I think happened is that the child was sick. Sick with diarrhea and vomiting, the messy kind of sick kids get. And she was overwrought, and she was unemployed, and she had 2 toddlers, and she was pregnant, and she had no help and no money. And I think the kid just urinated, defecated, and vomited on himself. And I think she picked him up. But the evidence showed that somebody picked him up by the waist and plunged him into a tub of basically boiling water. And
do you think that was out of anger or?
Oh yeah, I think it was frustration. I think she had reached her limits. I think she just had reached her limits. I didn't think that excused what she did to this child, and the fact that she took it to trial rather than pleading guilty when the evidence was so strong against her. I mean, my doctor said an 18-month-old child is ambulatory. They would have, if they would have gotten out of the tub if he was in there by himself. There was nothing preventing him. If he didn't, at the very least, he would have stood up to avoid the scalding water. But the burn marks were on his buttocks, and there was a mark around his waist that, again, what do you do when you're in hot water? A little child would be splashing, and the splashing would be everywhere. He would have gotten burn marks everywhere, but somebody held his arms on his side and plunged him in. And that I've always remembered, again, in part because it was a dramatic case and I felt so bad for the child, but also because it was, if I may say so, it was the most perfectly tried case I've ever tried. And, but I've also had some weird little funky things happen that only happen on TV. I had a gentleman come in and testify that he was a witness to a very, very minor crime. I mean, the crime was failed to slow to avoid a collision. Somebody had rear-ended someone else at a red light. And rather than just admit it and take his $40 fine, the defendant chose to fight the ticket. And he came in and said, I did not hit the man in front of me. The man in front of me backed into me at the red light. Now, why anyone would be backing up at a red light, I don't know. And furthermore,
actually, real quick, funny story. I had a police officer turn on their flashing lights, didn't look behind me at a red light, and legitimately backed into me. I was so scared they were going to blame me. I was like, he has every right, well, not every right, but he has every opportunity to blame me. But he took responsibility, and all his friends were coming up saying, they were saying, did you not see him with his lights on? I was like, no, he hit me. And they started making fun of him and ragging on him the whole night. But I was so afraid. They're like, they could put this right on me very easily.
Well, I'm still naive enough, or at least idealistic enough, to believe that most police officers are honest. I understand they're not all. But anyway, this guy not only testified to that, but then he got someone to come in and testify for him that he had been present on the scene and that he had seen my victim back into my defendant. And for reasons which I no longer recall, we had to adjourn the trial for a while. And while we were in an adjournment, I said to my police officer, run this witness. I don't know who he is, but run him. I want to know everything there is to know about him. And the officer came back and showed me the paperwork, and I looked at it and said, okay, I'm ready. And when we went back in, the witness had disappeared. But the defendant was still there, and I backed him into a corner by saying, now, that witness that you just had testify for you, did you actually see him at the scene, or did he just call you later and say he had been at the scene? Oh, no, I saw him. I saw him at the scene. He was there. I know he was there. And I said, well, pulled out my little sheet of paper that my cop had just given me. Would it change your testimony? When you hear that phrase, you know there's trouble coming. Would it change your testimony if I told you that the witness that just testified to that was in jail in Upper Marlboro for first-degree rape on the day of this accident? And at that point, the defense attorney asked for a break. He pled his client guilty. He begged me not to charge him with perjury, but I said, no, you don't do that. You don't not only perjure yourself, but get a friend to come in and perjure themselves and get away with it. So they ended up parlaying a $40 traffic ticket to a felony conviction for perjury.
Wow. What does that run on average?
Oh gosh, I don't even know anymore what the penalty for that is. Probably for your first offense, probably 0 to 6 months with probation.
Still, yeah.
But you still have a felony conviction for perjury.
Yeah.
And you can never serve on a jury. You can never have, you've been convicted of being a liar under oath. I mean, it's not a good thing to have saddled around your neck. And in the federal system, there is no expungement and there is no PBJ.
Wow.
So that's it. They're both got felony convictions now.
Wow. Now, going back to that first story, would intent versus negligence matter? So let's say the child legitimately scalded themselves, even though you said that's not what happened, but as a parent, you got to watch your kid in the bathtub kind of thing.
Yeah.
Would that have mattered in terms of sentencing or your case or?
Oh yeah. I mean, if this was an accident, if this was truly the kid did it to themselves. I mean, I have a 2.5-year-old granddaughter, and I know what kids could get into, and I know how quick they are.
Yep.
And I now cook on the back burners because I don't want her to be able to reach up and pull boiling water onto herself. So yes, it would definitely have affected the charges that were brought to her. If it was, as long as it wasn't gross negligence, she might not have been charged at all. Or if she was, it would have been not for the assault on the child. It would have been for, failing as, an appropriate, and I can't even remember the state law anymore because it's been 35 years, but it would have been probably lesser charges. But certainly at sentencing, absolutely. But this was not that case. But yes, of course, your intent always comes into play. I mean, so often defense attorneys would come to me and say, I know he was speeding, I know he was driving recklessly, but his child was at the hospital and he was trying to get there. And I would say, well, you and I both know that does not affect the charges, that affects the sentence. So if that's true, and half the time it's not, that's a mitigating factor at sentencing. It is not a defense at all to the charge.
Now, what were your feelings that the mother only got probation?
I was at the time very, very upset and angry with the judge. I thought it was far too light. I mean, I understood that she probably didn't intend to nearly kill her child, but the point is she did. And it was a deliberate act. This wasn't I think the bath is a little warm. This was, I'm going to hold you. I mean, he had to have been screaming. His skin was sloughing off his buttocks and his thighs. They had to, although he was eventually hooked up, they had to give him a colostomy bag because they couldn't have the feces traveling through the damaged rectum because the infection risk would have been too high. This kid was she almost killed him. And any mother who can hold her child in scalding water for the amount of time, which was about 20 seconds, and I counted it off for the jury.
That's forever.
It takes forever. Yeah. And I said, this is how long she did it. And I just looked and I waited and I waited. And I could see they were getting uncomfortable. And you have to be very careful. You don't want to make your jury that uncomfortable that they turn away from you. But I made them wait 20 seconds and said this, because I had my forensic evidence who testified that child was held in that water for 20 seconds. And the kid was screaming for 20 seconds. He was.
Oh, yeah. I mean, we pull our hands away if it's too hot within half a second.
Yes,
exactly. I can't imagine 5, 10 seconds, 20. That's forever.
Yeah. I mean, my memory may not serve, but it was something in the area of 20 seconds. And I made them wait that 20 seconds. And I said nothing except, and the child is still screaming. And then a few seconds later, and the child is still screaming, so no, I did not think it was an appropriate sentence. As the years have passed, I think I've come to terms with it, but I still don't think it's an appropriate sentence. No.
Wow. That's tough.
It was a tough case. It was satisfying because I got the conviction, but it was tough. Some of my child abuse cases, sexual child abuse cases, were even more frustrating because I'm dealing with parents, and sometimes the father is the abuser. But if the father's the abuser, chances are well above 50%. I'd say more like 75 or 80% that the mother knows it's going on, and at least through her silence is enabling it.
Is it usually family members with that type of situation?
Yeah, because they're the ones who have access to the child. And they're the ones who, like if a stranger does something bad to you, unless he can terrorize a child into not saying anything, and some of them can, it's usually a family member because they have the access. Who else has unfettered access to be alone with a little girl or boy? Nobody. Nobody.
So messed up.
Yeah. Yeah, we don't treat our children well. I mean, when you consider that the measure of a society is often said to how we treat our most vulnerable victims, which are the elderly and the children. We don't measure up that well. Never have.
What is the jury selection process like? What's the goal there?
It's torturous. I haven't done a jury in a number of years because in magistrate's court, we didn't have them. But there is a belief, I think fictitious, that you are tried by a jury of your peers, which to me would mean you go out and you pick the first 12 people off the street. and you say, come on, you're the jury. It has become so onerous that it can take weeks to pick a jury in a capital case. You have to know every single thing about these people. If they say anything, like some people don't want anyone who goes to church regularly because they will believe that, that people should be punished for their bad deeds. Other people, and so they'll try and weed out everybody who's religious. You get people who don't want young people because they don't want people who have a belief that, oh, I don't judge, well, that's kind of what your job is to do as jurors. And it just becomes, you got people like investigating juries sometimes. Probably not often because most of our cases are not capital cases, let's face it. But you've got notes on jurors, you've got everything you want to know about them. You have to go through this onerous series of questions. Has anyone been the victim of a crime or knows someone who's been a victim of a crime? Okay, it's a legitimate question. If you've been raped, maybe you shouldn't be on a rape case. But to say, yes, I know someone who was a victim of a crime because my neighbor's second cousin, who I saw once in a while when he was visiting my neighbor, had his car stolen.
Sure.
Will that affect your ability to, render a fair and just verdict in this case? And they normally say no, because if they want to be on a jury, they're going to say no, it won't affect them. Even if you think, how can it not affect you? And if they don't want to be on a jury, they're going to go, oh yeah, I couldn't possibly be impartial. When it's just ridiculous because your neighbor's second cousin got his car stolen. You can't sit on this, come on, really? So it's a bit of a pain in the neck, frankly.
So what, I know double jeopardy prohibits someone for being tried twice for the same crime.
In most cases, not always.
Sure.
There are exceptions.
Generalization.
Yeah.
What would happen if a jury member was asked a question and they lied about it, they convicted the person, and something in a case like that?
Very often that does happen. It happens frequently. I wouldn't say very often. And what happens then is that the defense is going to make a motion to set aside the verdict, and the judge is probably going to say no. And the reason being is that there's a belief that you don't pierce the sanctity of the jury room. That if somebody admits that, yeah, I really don't like Black people. I said I was okay with them, but frankly, I'm not. Is that why he convicted, or did he convict because the evidence was overwhelming? It takes a lot to overturn a verdict that was rendered in an otherwise appropriate manner by a jury because of what's called jury misbehavior. The defense will always ask for it, and they have to, because otherwise it's malpractice. But it doesn't happen as often as TV shows would have us believe, because it'd be very difficult to say that was what caused that one person to vote for acquittal or for conviction.
Now, what if it was the opposite way? Let's say the person was voted not guilty mainly because a jury member was like, oh, my cousin Mikey went to jail and it wasn't fair that he went to jail. I'm going to vote not guilty no matter what. I'm going to convince this whole jury, or I'm going to at least hang the jury. And it comes out later, like he had this agenda. That juror had the agenda the whole time to vote not guilty. Would it be possible to retry that defendant?
Well, and unfortunately, like everything else in law, the answer is it depends. If he managed to convince the other 11 people and they ended up with an acquittal, no, that's over.
Okay.
That's done.
Okay.
If he hung the jury, you can always retry on a hung jury. I've done it. I had a hung jury and we just went ahead and retried because it's not double jeopardy. So if that happened, it would depend on whether he was able to convince the other 11. But if he was so silver-tongued that he managed to convince 11 other seemingly intelligent people who had heard the same evidence that this guy didn't do it, that's just so bad, so sad, it's too bad. No.
Wow.
Now, once you're acquitted, it's over. Now, I suppose there's, I always tell people I spoke to when I was teaching the new prosecutors, sometimes if your front door slams in your face, go to the back door. The back door go through the window. If you have to, come down through the chimney. If you can find a different sovereign, so to speak, in other words, state versus federal, and you can find charges that are different enough that it can pass constitutional muster, sometimes you can charge other charges that are sort of based on the same thing, but like
loose. Yeah. Like,
yeah.
Would conspiracy be one of those?
I'm not following. What do you?
Like, let's go to homicide. So they get acquitted, and then let's say a video comes to light of them doing it. They did it. Could they like how would they be able to charge them for something
Not
else?
really. No. Well, you mean like assault?
Yeah, anything.
Probably not. I mean, I'd have to think of, every permutation that you could do it.
Sure.
Like if it, like where I think that comes in more, and again, this is not my this is not my area of practice for the most part, but if you had a police officer and he was charged with murdering somebody and he was acquitted, and then the video comes out, you might be able to charge him federally with the violation of civil rights based on the behavior that caused the death, that type of thing.
So separate sovereign kind of thing.
Yeah. It's double jeopardy only prevents you from being charged twice by the same sovereign. And that would be state versus local. Now, there's always other side issues of whether this is fair. Is it unjust? If it is, a court could say, well, technically we could see it, but it's unjust. And they could dismiss on those grounds. So, the law is so fluid, and that is both its frustration to most of us, but it's also what makes it a living, evolving, growing, sometimes shrinking thing. Because you can't have one rule for every situation, because every situation is different, and you shouldn't. And that's why when I say it depends, and I can sort of see the eye roll in my audience, it's supposed to depend. It should depend. Yeah. Because we're not, there's got to be room for movement. If it was too rigid, we'd have miscarriages of justice far more than we do now.
All right, so pretty big question, but do you think there are any problems with the legal system?
Oh, God, yes. I mean, yeah, there's problems with the medical system. There's problems with the teaching system. Yeah, there is. It has gotten so cumbersome and so complicated that the average person cannot understand it anymore. And what you can't understand, you have a tendency to either fear or hold in contempt or idolize. And none of those are appropriate reactions to the law. The law should be something that serves everybody. It's not a god, but it's also not, an evil monster that will screw you. But it is complicated. And unfortunately, I don't see how to get away from that anymore. I don't understand how we can it's like the tax code. We keep trying to streamline it and we don't seem to be able to.
It's terrible.
It is. And thank God I never had to do tax law.
So are there any specific instances of you going, hey, that's terrible, this needs to be fixed, in regards to the law in general?
I mean, in criminal law, which is the only area that I can really.
Sure.
No, I mean, not one particular area. I mean, there are things that drive me crazy as a prosecutor. The rules against hearsay are difficult to deal with. For one thing, there's so many exceptions that sometimes I wonder why they even bother with a rule against hearsay, because I can usually get it in somehow. But then you get into a situation where you really need to get certain evidence in and you can't, because, it does violate the hearsay rule and there's not necessarily a exception to it. And it's perfectly good evidence. What I suppose the most, I'm sort of shifting gears. I think the most frustrating, and yet I don't think I would still change it, rule of evidence is the Fourth Amendment, the rule against unreasonable search and seizures, which is a wonderful thing, and I wouldn't change it. But the penalty for the prosecution is that the evidence gets suppressed. So if you are stopped, it's the classic example, you stop a guy for speeding, you have no reason to go into his trunk, but you do, the police officer does, and there's the body. You can't use that body. He's going to get away with that unless you can find some way to get it in. And obviously that depends on so many circumstances. So you get a lot of people who are in fact guilty being let off because it violated a rule. Now, if that rule is to prevent wrongdoing by the police, I understand. And generally, if it's innocent, the police don't realize they're making a mistake. The judge will often let it come in anyway. But that's the kind of thing that is very frustrating. You get a lot of, I think sometimes judges over suppress in rules of suppression, over suppress otherwise good evidence. The officer explains that the guy was nervous and he was sweaty and he kept looking toward the trunk and, he was tapping his fingers and he was doing this and he kept looking to the trunk.
Yeah.
And, maybe even said, "You're not going to go in my trunk, are you?" I kind of think that any good cop is going to go in the trunk.
Yeah, at that point.
Yeah. Okay. And maybe not every judge would suppress that. Maybe some judge I could find would agree with me that gives them, some probable cause. But what a judge is going to say is, how do you know as a cop, how do you know that what he was nervous about you finding wasn't, he's a drag queen and his clothes and wig and makeup and, it was in the trunk and he's the school principal and he doesn't want anyone to know because he lives in a small town. And, and I guess, again, I
just
don't
like
know.
Private information that they want. Yeah.
Exactly. Okay. Private information is in there. But, that's an area of the law that is extremely frustrating. But again, what's the answer? Just letting a cop stop you and search your car without probable cause? I don't think I want to live in that society.
No, not at all.
So yeah, sometimes there's a bad result, but it's generally for a good purpose. I mean, the judges, I think, all do their best and they try very hard to walk that fine line between allowing the police to be effective investigators and yet not allowing the citizens just to be prey to every curious cop who wants to go and see what's in your trunk.
Yeah.
So I can't think of any one area that I think, oh, that's really got to be fixed. Again, it's evolves and it changes. And, everyone said, oh my God, we'll never get another criminal conviction when Miranda came in and,
sure.
Who's going to confess after they're told they don't have to? And yet they do it all the time.
Yep.
About 5, 6, 7 years ago, the McNeely case said that on the Parkway, the U.S. Park Police could no longer force a defendant to give a blood sample because it's an intrusion. It's a search, in the most personal sense. You're putting something inside somebody's body. And so what we had to do is set up a system whereby if somebody was under the influence and was refusing to take a breathalyzer or took a breathalyzer, but we believe they were under the influence of drugs, which don't show up on a breathalyzer, we were now calling judges in the middle of the night and waking them up and saying, we would like a telephonic search warrant for a blood draw. And everyone said, this is the end of it. We'll never get them. The judges won't, but it worked out.
So kind of like the police officer pulls up based on their training, knowledge, and experience. They see behavior of under the influence of drug. Then you called the judge.
Yes.
Okay.
Yes. Now there was some jurisdictions, most of them were state jurisdictions, where the judges simply said, we're not getting awakened in the middle of the night. We just won't do it, which frankly, I think is it's an abrogation of their responsibility. I mean, nobody wants to get up in the middle of the night, but that's part of your job, Judge, sorry, And then for a while, what they were doing was saying, well, a cop couldn't call the judge until a U.S. attorney had approved it, which I got to admit, crossed my mind that maybe that was just a way of, well, if I have to be awake, so do you. But
did that ever pass? Or they had to call you
when I left, they really weren't too much. The judge had, we had some great judges, and so if somebody would be on call and somebody would have to bring a little recording machine and they would answer the phone and they would set up the machine and say, okay, Officer Smith, give me your give me your probable cause. And sometimes the judge had questions, and generally they issued it. I think what we did is, instead of calling the state's attorney, or the U.S. attorney, we settled for the officers not calling the judge directly, but calling a supervisor who was already, a sergeant who was already awake and on duty. And that person would approve the call to the judge, so that we weren't getting judges awakened in the middle of the night for no reason. Yeah.
Sure. So in psychology, my students learn about how fallible human memory is. And there are a ton of studies out there that support this.
Mm-hmm.
For example, humans are susceptible to suggestion, leading questions, misinformation, and in general, human memory isn't that great. So since human memory is so prone to error, should eyewitness testimony be used in court?
It has to be, because there's too many cases where the only evidence is eyewitness testimony. And if you don't have eyewitness testimony, people would have carte blanche to commit certain crimes. Let's say you punch me in the stomach. I can say I was punched in the stomach, but there's no proof unless there's a bruise. But even if there's a bruise, I could have walked into a doorknob. And even if I walked into a doorknob, it doesn't, or even if somebody believes I was punched in the stomach, that doesn't mean you did it. What testimony is going to say that you did it?
Sure.
My eyewitness testimony.
Mm-hmm.
So there has to be.
Mm-hmm.
And there is, I've read those studies, and I do agree. There's a lot of fallibility in eyewitness testimony, but we have nothing better other than closed circuit right now. I mean, and we do have a lot of that. I mean, people have their cell phones are everywhere. Everything's on, I think the cell phone coverage is what got that officer in, Derek Chauvin convicted. Without it, he wouldn't have been convicted. I do understand that there is a lot of problems with it. There's a lot of cross-race error. People are shocked and they don't know what they've seen. Somebody walks into a bank and starts shooting, and, you've got them everything from, wearing a blue shirt to wearing a red polka dot shirt and things like that. And I think that can be at least somewhat mitigated by a defense attorney presenting evidence that eyewitness testimony is false. But eyewitness testimony, many crimes take place between people who know each other. I'm not going to mistake my husband for somebody else. I'm not going to think I saw my husband when it was actually the next door neighbor. So to a large extent, that's not, it's eyewitness testimony, and I'm probably as gullible as anyone else and as susceptible to misidentification as anyone else, but not in certain circumstances. I can tell my husband by the way he walks. I can see him so far away, I can't see his face, but I know it's him. We all have that experience. I know my daughter's voice on the phone. And if I'm not allowed to testify, how am I going to show it was her? If that's important to the case. So I don't see any world, anytime, anywhere where eyewitness testimony would be completely eliminated, unless you're just going to say certain crimes are no longer crimes. But I do think that a good defense attorney can mitigate it with evidence. And if it's a big, important enough case, or if the issues are truly there, like it is a group of startled people, strangers coming in, like strangers committing the crime and then taking off. I think testimony by an expert, a forensic expert in memory or psychology, as you seem to be familiar with, can at least plant the idea in the jury's head that think of this with a grain of, with a little bit of a grain of salt.
Sure.
So the answer is, I understand the problems, but no, you just can't. And it shouldn't be. I mean, what if you're raped by your neighbor who you've lived next to for your whole life, but you can't testify to it?
Sure.
Because you might misidentify him? I'm sorry, but I know what he looks like. He was there.
Have you ever had a case where someone's just mad at another person and brought up false accusations?
Not to my knowledge. I mean, I wouldn't go forward.
Yeah, I don't know if anybody's been arrested, and then you found out later you were working on it, like, oh, actually,
I'm sure I've had cases where the more I looked into it, the more I thought, he pushed her, and maybe I did have something sort of. I'm not sure if this is what you're asking. This woman was engaged to be married or married, And her fiance's ex, who he had nothing to do with, the man had done nothing wrong. He had some crazy ex who was angry at the woman he eventually married or was engaged to. She went up to the woman and did something to her, pushed her, shoved her. I can't remember what she had done. And the defendant, who in my opinion was probably not really the guilty party, retaliated, but she kind of went overboard. Like the woman was calling her names and she dumped a pail of water on her head or something, something like that. And we didn't realize that she had been provoked to the extent that she had been provoked. We didn't realize that our quote unquote victim had been trying to steal her husband. And for some reason, the husband didn't come up and tell us that. And I remember saying to him, had you told me the whole story, I wouldn't have prosecuted your fiance or wife. Because while I think she was technically a little bit out of line for what she did, she could have done a lot more than dumping a pail of water on this woman's head. She didn't injure her. I think she ruined an expensive hairdo or something like that. So in that case, my victim was kind of taking advantage. She was so angry at this woman for having won the man that she had kind of insisted that we prosecute for it was an assault. Technically, it was an assault. That if I'd known the whole story, I probably would have just said, you know what, keep your business out of my courtroom. Settle your problems in a more ladylike way and get out of here. So I'm not sure if that answers your question, but
that was good. What advice would you give someone trying to become a lawyer?
Make sure it's what you really want, because there are so many lawyers who are unsatisfied. I don't know how to make sure it's what you really want. Make sure you have a passion for what you do, because it's just one of those jobs that can be so grinding and so difficult. And you're always on edge because you're always on the verge of thinking you make a mistake. It's sort of like being a doctor, although I guess not as serious. They make a mistake, their victims are dead. You make a mistake, your victim can really, the victim of your mistake, your client, can be really injured, either financially, socially. They can go to jail when they shouldn't. If you forget to present a defense, they could end up in jail. If you don't know how to schmooze the prosecutor. I hate to make it, bring it down to that level, but, make sure it's what you really want to do, because you're always there's too many, I'm sorry, I'm not being articulate here. I have spoken to too many attorneys who are miserable. I guess that's what I'm trying to say. They say it's not worth it. The pressure you're under, the clients who never stop calling you, especially now with cell phones, because they can get you 24/7 and they expect to, the ones that want you to do things for them that aren't particularly ethical, the ones that want you to do things for you and then you do them and then they don't want to pay you. It's a grind. It really is. I can't think of another area of law that I would have been happy doing other than prosecution. And part of it is because I don't want the problems involved in running my own business. I'm not entrepreneurial. I don't want to pay rent. I don't want to make sure my insurance is paid up, although I do have malpractice insurance. I don't want to make sure that my secretary comes into work. I don't want to worry about deadlines. I don't want to do any of that stuff. But I guess that would be, and law is one of those fields where there is an infinite number of fields that you can get into within the field. You can do what my husband did, which was he worked for the Federation of Tax Administrators, working on tax policy. He sat at a desk all day and did research and writing. He loved it. That's his personality, not me. I would rather watch paint dry.
Yes.
That would be considered cruel and unusual punishment. There are defense attorneys in the criminal law. There's civil attorneys. There are attorneys who work for the FDA. There's people who work for there's not a field that doesn't need law because it's such a giant. Yes. You could be an entertainment attorney. And so that gives them a lot of choices, but just don't go for the money. Just don't fall for that. Just don't, because if that's the only reason you're doing it, you're not going to do a great job and you're not going to get the money. So it's not even going to accomplish what you think it's going to accomplish. So the other thing I would tell anyone who is going to get into law is if you start to hate it, get out. Just don't do it anymore. It's not the well-paid job people think it is for the most part. It really isn't. Yeah.
Have you, kind of switching gears here, have you or any of your colleagues ever been nervous about, being attacked by a defendant or defendant's family or something like that?
No, I'm sure some of them have. I worked with a woman. In fact, one of the few federal felony cases that I did was with this attorney who prosecuted. Oh God, what was his name? He's very well known in DC, a big drug dealer. And if you said his name, I'd go, oh yeah, that's him. And they had to give her protection for a while. And they put in an alarm system in her house, but it wasn't because she had been threatened. It was because they just didn't know. There have been one or two cases in the last 4 to 5 years before I retired where there was an active plot against one of our U.S. attorneys by a defendant, but that was very unusual. For some reason, and I'm totally guessing here, they seem to accept the fact that the prosecutor has a job to do. They get more angry at their attorneys, their own defense attorneys, for not getting them off than they get at the prosecutor. They don't like me. I've been called every name in the book in court, in front of the judge, but they don't seem to ever want to take it out on me. I did hear about one attorney, one prosecutor, who did not get assaulted, but a guy in the bathroom who was his lookalike was assaulted. And later it came out that the defendant thought he was beating up my friend Kurt, because they looked alike. They looked similar. And I guess that's your eyewitness testimony. He just got convicted by this guy, went in the bathroom and saw somebody who looked vaguely like Kurt and said, oh, you're the son of a bitch who just prosecuted me and beat him up, and it was the wrong guy. But those are like the only 2 or 3 instances in 35 years of prosecution that I can think of. It doesn't really happen that much. No, that's more like law and order stuff.
Yeah. What about like jury members? I know that their names aren't released to the public, but I mean, correct me if I'm wrong. I could come see a court case, and what if my brother's up there and I'm a bad person and I see that juror walking down the street 5 years later, you convict my brother. Like, do you ever hear cases where jury members have been attacked or anything like that?
No, I don't know why. I mean, again, it's probably because these people are criminals, but they're not the smartest people in the world, or the sharpest knife is in the drawer, and they generally just don't do that. I mean, I'm not saying it's never happened. I'm sure somebody would go, well, I remember a case where, but no, it doesn't. And if it's really a bad actor, I mean, if it's really a hideous, bad, violent, like MS-13 types of people that might do stuff like that, they can sequester the juror, and they're not even, their names may not even be used. They're just juror 15, juror 12, juror 8. Could it happen that you see somebody walking down the street and you go, oh my God, I recognize them? Yeah, I suppose it could. Unfortunately, in a case like that, if the person was assaulted 3, 4, 5 years later, they probably wouldn't connect it with what had happened 3, 4, 5 years earlier. So he or she would just be another victim. So not that I know of is, I guess, my answer.
Do you have any cases that just like frustrated the heck out of you because the person got off?
Oh God. Yeah. Most of them were the sex and child abuse cases that I dealt with when I was a state's attorney, not a U.S. attorney. And, the defense attorneys will always say things to the jury like, in this day and age, all you have to do is whisper child abuse, and the jury wants to convict my client. And I beg you not to do that. And I'm thinking, it's actually the opposite. To label somebody a child abuser or a rapist or, somebody capable of committing a heinous crime against anybody, but especially a child, is very, very difficult. It is very difficult for jurors to look in the eyes of a man and say, you had sex with your 5-year-old daughter, you animal. And they look for ways that it couldn't have happened. They look for ways that excuse the behavior. They look for alternative defendants. They got the wrong guy, otherwise known as SODDI. Some other dude did it. The SODI defense. They look for the child doesn't know what they're talking about. They look for any excuse in the world. And so when you get a child or a victim, even an adult victim, who maybe doesn't report immediately, and you try and explain to a jury, because in a sex or a child abuse case, educating your jury is job number one. Because they don't understand, why would a woman not report right away? Well, she doesn't report right away because, let's face it, having your sex life splayed all over, for your, having the physical exam is pretty intrusive. Having your defense attorney or the defense attorney wanting to know when the last time you had sex was, and could that sperm in you have been from, your other partner, having the defense attorney ask you, well, didn't you lead him on? Didn't you encourage him? Didn't you want it? Isn't this it's an unpleasant, ugly experience that most women do not put themselves through voluntarily, and sometimes not at all. We still have by far the lowest reporting of any crime is rape. And there's a reason for it, because, no offense to you, men made our lives so miserable. The male attorneys, the male police officers, the male, there wasn't that many women in the field for a while. The male judges who would say, like, what were you wearing? Like, what does that matter, judge? What does it matter what I was wearing? What does it matter how much I had to drink? I still didn't ask to be gang raped and thrown in a dumpster. So that kind of ignorance still exists. Maybe not as much as it did even when I was doing it 30 years ago, but it still exists to a large extent. So that is a source of constant frustration. They don't understand why a woman wouldn't report it, why a child would recant. You try and explain the child abuse accommodation syndrome, and they say they understand it, but they still say, well, I don't know, she did recant. That's a source of frustration. The other source of frustration is actually something that is what we call the CSI effect. Jurors seem to think that everything has forensic evidence. I had a jury acquit a man who had given his daughter, we believe, he denied it, he said it was from somebody else, but we believed had given his daughter gonorrhea. And when it was over, the jury did not convict. And when they came and talked to me, which they are permitted to in the state system, it's very hard to do in the federal system, but in the state system, you can approach your jurors as long as you do it politely and respectfully and say, can I ask you? Well, maybe it's changed in 30 years, but when I was practicing, you could, are you willing to speak to me? And if you are, can you tell me what my case didn't have? What would it have taken to convince you? And about 3 or 4 jurors in that case said, we really believed he had done it, but we wanted more evidence. And I just had to walk away because I couldn't be civil. Like, what more evidence do you want? The child doesn't have fingerprints. First of all, even if she had fingerprints on her body, he's her daddy, they belong there. But, what do you want other than gonorrhea? Someone did that to the child. And they said, well, yeah, but it could have been the babysitter's son. I said, did the child say it was the babysitter's son, or did the child say it was her father? They can't look someone in the eye and say, you did that to your baby girl. So that is a source of frustration, and a source that they seem to want more evidence than, like, why don't you have fingerprints? Because you don't get fingerprints off a loaf of bread, you morons, that kind of thing. You can't say that, but you kind of want to, and the defense attorneys know it and they play it up. Mm-hmm. You're not going to hear anything about fingerprints. Did you get any DNA off that car door? Well, no, because it was winter and the guy had, gloves on. They really take advantage of this CSI craze, this forensic evidence. Everything has to have forensic evidence, or you can't convict. And they'll tell a client that. They'll tell the jury that, rather.
Wow.
You just deal with it. You just do your best.
So that's another thing crime shows get wrong. Everything has
everything. Evidence. Yeah. Oh, somebody's been the evidence has been buried in the dirt for 27 years, and somehow they managed to get a fingerprint off it. Like, really? They do that? That's amazing. Yeah, they get it wrong too. So yeah, there's a lot of frustration, but my God, it's so worth it. It's the best job in the world. It's fun, it's funny, it's exciting, it's hard, it's frustrating. It makes you feel like you're doing something. It makes you feel For those of us with an ego, you're going head to head with another person. And I mean, I always say I don't like competition, but I thought, well, damn, that's not right. Look what I do for a living. I'm not competitive. Really? Anyway.
On average, I guess this is, again, a generalization, but how long would it take you to prepare a case that went to trial?
Depends on what case.
Okay.
Obviously, the case of the little boy who had been scalded by his mother, months. Mm. The case of a DUI with no extenuating circumstances. I tell you, I wouldn't want to do it, but if my coworker called in sick that day and asked me to take her docket, I can go in and try it by the seat of my pants. Because I've done it, it's so simple. There's nothing about it that is unusual. I would probably take 5 minutes just to look at the file, talk to my cop. You trust your cops after a while, and you say, "Is anything about this case stand out? Anything I need to know right now?" And so it depends. It also depends on how complicated the case is and how strong your witnesses are. I had a little boy in a sexual abuse case that it took me months to get him to talk to me. Whenever I'd go speak to him, he was hiding in the corner doing this. And I had to go see him 4 times before he would even take his hands away from his face. And then he didn't want to talk about it. And when I finally got him to open up, my investigator brought his son, who was the same age, like 8 or 9 or 10, I can't remember anymore. And we took him out for ice cream and we let the boys play, and we kind of, got him to relax a little bit. He never completely opened up. He never openly or easily talked about it. But, that took me more than it normally would have. As traumatic as a bank robbery is, it's less traumatic, and witnesses tend to speak more easily to prosecutors when they say the guy came up and put a gun in my face and slipped me a note, as opposed to, my uncle's been sneaking in my bedroom every night, making me do the dirty deed. Sometimes you get a parent who's not being, as I explained earlier, who isn't cooperative, and that takes time. Sometimes you get a social worker who says the kid's not up to talking about it. You got to give him another month of meeting with me on a regular basis. So that takes time. So your question is really, it's like saying, what's it, how long does it take to cook a meal? Well, a souffle versus a peanut butter and jelly sandwich,
I got you. Any just kind of parting thoughts that maybe high schoolers should know about the law or being a lawyer or anything like that in general?
90% of the people in this field, like 90% of the people in every field, are doing the best they can do. They're not dishonest. They're not sleazy. Even the defense attorneys, who I butt heads with constantly, are basically decent people, and they deserve your respect, and they deserve your good manners, and they deserve, to some extent, your admiration, because they take a very difficult job, and they do what a lot of people don't want to do, which is get up in a room full of people and talk. And I have a sister who always claims that all Nathans suffer from stage fright, but in our case, it's fear of not being center stage. And to some extent, she's right. But I do understand that for a lot of people, what I do is very intimidating. And even for some of the attorneys who've chosen to do it, it can be intimidating. So go easy on our profession. I know everyone loves to say, "Oh, kill all the lawyers." They misquote that Shakespeare and they take it out of context. But and everyone loves to bash attorneys, that like we're all dishonest sleazebags who'll do anything for a buck or anything for a win. And that's just not my experience. It just isn't.
Well, thank you so much for your time.
You're welcome.
It's been very enjoyable.
I hope so.
Conversation. I've learned a lot.